Hello, everybody. Welcome to session number 12 of the Introduction to the Ethics of AI. As you see, I had to stay in my office today because in Osnabrück there is a big bomb disposal operation and we cannot teach in the lecture hall. But still, let's continue with our lecture. First of all, before we start into the contents, I would like to bring to you some announcements concerning the exam. As I told you already, the exam is in the last week of term, which is on the 15th of July. Let's start very much on time, so please be there at 2 p.m. and the time slot will be the usual time slot. The exam is an in-person only exam. There is no remote participation in it. You will be working on paper. Please bring a pen, which is a permanent pen, such as a ball pen, for instance. It will be a multiple choice exam, so it's only about ticking boxes. And the exam will be not in the lecture hall, but in building 1. I have because we have to fit 280 people in the lecture halls, and I can only use every second row and every second seat. So I reserved the very big Audimax lecture hall 01E01, which has 500 something places. And we also have 01B01, which is a lecture hall in the basement of the building 1 that fits another 200 people. So please do not go to this building here, which is building 15, but go to building 1 and you will still get some instructions which of the 2 rooms is your room. I think I will put out a range in terms of the first letter of your last name, according to which you have to either go in the one or in the other room, so that you will be seated and that we distribute people appropriately between the 2 rooms. But please keep that in mind, that you do not come to building 15, but to building 1. Also, please keep in mind that you will have to register for the exam on EXA. If for any reasons EXA registration does not work for you, please come anyway. The thing is that EXA registrations are still open until 1 week before the exam, so you can still do it even if it might not have worked in the past. So please give it another try. It makes our work easier if you are registered. But if registration doesn't work, please come anyway so that you don't miss the exam. And I try to publish an always updated list of comments and remarks concerning the exam on the website, which you find here. Another administrative topic is that I would like to ask you to participate in the course evaluation for this course. It takes you 5 minutes. You can even stop the video and do it now. This is of great help and great importance to me and to our work group as a whole, because first of all, this is important feedback. It is the first time that this lecture has become a compulsory lecture, and this is why it is particularly important for us to get feedback. Also, it's always important to learn how the hybrid format works. The hybrid format, that we put it out as videos, as a live stream, and on site. This is actually a service to you. We don't have to do it, but I think it increases flexibility and is also inclusive to people who have other things in parallel, including care work and other non-university things. But I never see you if you participate in the video, so it would be nice to still get some feedback. The feedback will help us to fight for resources such as the money we need to operate the discussion groups. In this regard, I also ask you to participate in a separate course evaluation for the discussion groups that will be brought to you by your tutors in the next weeks. So you can stop the video now and do it, or you can do it later. I will remind you at the end of the session. As always, let's start with a little recap of last session. Last session I started into the topic of regulation, and I tried to connect that to talking a little bit about the fundamentals of our legal system, especially with regard to the rule of law, but also to fundamental rights. And then I started with the foundations of data protection, and we will continue that today. As I told you, among the very core elements of democratic systems are such things as the separation of powers, or the rule of law principle, which maintains that the same law applies to everybody, and that there are some procedural guarantees concerning how the law is being applied and how justice is accessible to everyone. And in the Rechtsstaatsprinciple, there is also a very strong commitment to protection of the fundamental rights, and so on. I also tried to tell you about the core differences between legal systems. There are many different kind of flavors or general structures of legal systems in the world. In the global north, there is mainly this difference between common law and civil law. It has been historically rooted, and remarkably in the Anglophone countries, so in North America, but also in the UK, we have this common law tradition, while on the continent in Europe, we have the civil law tradition. Civil law is codified law. Parliaments decide on codified law. The codified law has to be compatible with the constitution, and the justice system applies the law to single cases by subsuming the single cases under the codified law and then deducing consequences, while in the common law system, the justice system also creates law by making case law and by judging by similarity to previous cases and setting precedents, and therefore have a much more active role in creating the law compared to our systems. I think that this is mainly interesting because the difference between privacy and data protection is also something that the full depth of which you can only understand when you understand the difference between these two legal systems. Yeah, I then started into the topic of data protection and told you that there is this fundamental difference between privacy and data protection. While privacy is an idea vastly focused on individual rights or the right of the individual to control access to their personal data, it assumes something like a private sphere. It is very much about you vis-a-vis the others, vis-a-vis the public sphere, vis-a-vis society. While data protection, the reference to individual data is only kind of the vehicle for the protection against power asymmetries. Yeah, in data protection, the main idea is that we should regulate power imbalances that get too strong, to the disadvantage of individuals or society at large. So even structural concerns might be concerns of data protection, while they are usually not concerns of more classical conceptions of privacy. And therefore, data protection is more a political project than it is an individual project. And to make things even more complicated, there is this whole confusion in translation. Privacy is too often translated as data protection to other languages, or data protection is often translated as privacy in English, which is often inappropriate. Another key distinction that you should remember definitely is that data protection is not the same as data security. Data security is the technical business of protecting data from things that could happen to it, yeah, from unauthorized access or theft, all the way to manipulation or accidental loss of data. This is something that might be part of data protection strategies, but data protection is not really a technical matter only, or maybe only even the technical part is really only marginal in data protection. Data protection is organizational and political structures that protect your fundamental rights against anything that any infringement that could result from the processing of your fundamental rights of your personal data. Yeah, and as I developed in the last lectures, there were a couple of takeaways. Data protection aims to limit the imbalances of power between individuals and organizations that process the personal data. Data protection protects individuals in society against infringements of fundamental rights through that data processing. And the primary attacker in data protection are always the data processors themselves. So, for instance, if you process your or if a platform company processes your personal data, the primary data protection problem is not hackers or spies hacking into that platform and stealing your personal data. This is an attack that might occur, but the primary, so most risky data protection issue is the data processor themselves, so the platform company, and because they have all the data first of all, and they can do a lot of mischief with the data if there was no regulation and oversight in place against this. I then turned to the fundamental rights, clarifying a little bit what this is. As I told you, fundamental rights have in the legal interpretation that I'm using here two dimensions. The one is called the subjective dimension. This is fundamental rights as defense rights of the individual, primarily against the state. Yeah, fundamental rights are very basic guarantees that everybody has against the state. And it is called subjective because it applies to everybody personally, and you can defend yourself legally by a recurrence to that right. But there's also, as I argued to you, an objective dimension, which is more the aspect of like a fundamental legal order that is kind of inspired by the fundamental rights. And that means that the state has also the duty to maintain the constitutional rights as an objective order of values. And as a consequence, fundamental rights establish the duty of the state to prevent violation of these rights, but also by third parties. Yeah, so we see two aspects in this objective dimension. The first is the preventive aspect. Because defense rights, what we have in the previous bullet point, defense rights are always ex post. Yeah, you can only exercise them once a violation has taken place, but that might be too late. And therefore, in this legal doctrine here, one tries to interpret fundamental rights also in regard to a preventive function, so that the state has the duty to prevent violations of your fundamental rights before they even happen. But this is then not due to the defense function, but due to the objective order of values function of the fundamental rights. This is the first aspect in the second bullet point, and the second aspect in the second bullet point is that this then also applies against private actors and not only state actors. Yeah, so that the preventive function or the prevention of violations of your fundamental rights is also vis-a-vis private actors for sure, and not only the state. And this is how data protection as a protection of fundamental rights also applies to private data processors and not only to the state as a data processor. Yeah, today I will turn to the EU General Data Protection Regulation. And as a general topic of the day, I will introduce the landscape of EU digital legislation to you, but we will start here with the GDPR and then go into some of the more recent digital legislation acts in the next 3 parts of the lecture. As it is really weird talking only to my computer in the office, I will reuse the recordings from the last year for the next 3 parts, so that I will cut now and I will kind of use the material and cut it into this video here. So thank you very much for listening and see you again next week. But please hold on, we will start now into part number 1. Yes, as the last part of today, let's, after all this systematic approach, look into the EU GDPR, the EU General Data Protection Regulation. It is a vividly debated legislation. Before the AI Act, it used to be the most lobbied legislatory project in the EU history, in terms of lobbying money that went into influencing this legislation project. That was, before the AI Act, the record. I think from the conservative side, the GDPR also has a huge appeal. And the main appeal from the conservative or pro-business side is that it harmonizes data protection regulations across the EU to ease trade and flow of data. It's very important that all data protection and privacy legislations, also in the US, always also serve the purpose of enabling data processing in the sense of legal certainty. That you have legal security, what kind of data processing you can do. And in the case of the EU GDPR, before that, there were as many single data protection regulations as there were countries in the EU, plus, for instance, in Germany, every state, Bundesstaat, has their own data protection regulations and so on. So there was a large bundle of different legislations that apply in different contexts that would severely hinder EU-wide business or EU-wide offers. The main appeal from the progressive side, or more social inequality and anti-discrimination side, is that the GDPR has clear impulses of regulating power asymmetries, as I tried to introduce already. The GDPR was not even the first EU data protection statute. It's superseding the Data Protection Directive from 1995, and it was adopted in 2016 and enforceable as of May. Oh, there was always the birthday last week, 2018. And it's, I don't know how much of EU stuff you know, but it's a regulation and not a directive. There's this difference between regulations and directives. Regulations are binding immediately. Directives need to be re-implemented in national law, so they are not immediately binding, but the GDPR is a regulation which is immediately law, that immediately is valid and enforceable in all EU member states. The UK, after Brexit, retained the GDPR in almost identical form as the UK GDPR, so that they do not have considerably weaker data protection standards after Brexit. It is really a good idea to have a look at this regulation. For instance, when you look through this lecture, after the lecture, you can read it. It's readable. It's not. I will talk about this now for another 25 minutes. But maybe some of what I say is much more immediate when you just read the first 10 articles or something. Okay, let's introduce you to this legal instrument. What is the scope? It's always an important question when you approach a law, a piece of legislation, like to what does it apply? What is in the Anwendungsbereich of the law? And the scope of the GDPR is the processing of personal data. So what is personal data? According to Article 4, paragraph 1, it is personal data means any information relating to an identified or identifiable natural person, which is also referred to as the data subject. Yeah, it's sufficient if the person is identifiable. It doesn't need to be identified in the data set. For instance, if it's data about someone and you can uniquely find that person by some effort, this is personal data. Yeah, for instance, by asking everybody and matching certain criteria, and then in the end you find the one person, then it's still personal data. If an individual cannot be identified directly from the data, it must be considered whether identification is possible in combination with other data. Pseudonymization is therefore personal data. Yeah, a pseudonym only removes unique identifying information, but replaces them with a unique identifier that is a chiffre or something. And this is still personal data because it can be recombined or relinked to the original person. Anonymized data, whatever that is, anonymized data, we will talk about that in one of the next lectures, because it is a heavily contested term, also on technical grounds. Anonymous data is not in the scope of the GDPR. Yeah, if you can prove that your data, the data that you gather from, for instance, your customers or from hospital patients or from the people who made some experiments in your lab, that you anonymize the data in such a way that the link to the persons cannot be reconstructed by even considering additional information or additional data sets, then you are not, the data does fall outside of the scope of the GDPR. This is actually important. It leads to one of the major caveats of data protection regulation in the age of AI that I will be talking about in the second next lecture, because for the training of machine learning models, anonymous data is usually enough. Or the training procedure of a machine learning model might be an anonymization procedure at the same time if you do it well. This is why many of the harms connected to AI, especially machine learning, you can do with anonymized data, and then the training and using of these models falls outside of the scope of the GDPR, which is a limitation that the architects of the GDPR were not thinking about when they were designing this legislation. This is why I put the exclamation mark here. I will get back to that point in due detail, I think, in the next session. Who does the GDPR apply to, or what are the kind of the actors in the system of the GDPR? Among them, there are the two most important actors. They are controllers and processors. The controllers, and it's important that the GDPR makes this distinction. The controller is the entity that determines the purpose and means of processing of the personal data, but it doesn't necessarily process the data themselves. Yeah, for instance, if you gather, or if you use some third-party purpose to analyze your experiment data, you are the controller but not the processor, but the processing is done by the third-party service. The processor does the processing of the personal data on behalf of the controller. And in some of the provisions of the GDPR make a distinction between these two. The GDPR also applies to controllers and processors outside of the European Economic Area if they offer goods or services to or monitor the behavior of data subjects within the European Economic Area. So in distinction to the US legal situation, you can see two things here. The GDPR applies to the processing of personal data of anybody, especially not only of the citizens of the EU, but of people in the EU or in the EEA, which is much broader because there are many people here who are not citizens of an EU country. And secondly, it also applies to data processing that takes place outside of the EEA, European Economic Area, if it is about the processing of data of people within the European Economic Area. Yeah, that is a very broad and therefore general scope, and that's why it's called General Data Protection Regulation. Especially, as you can see, there is no reference to a domain. Yeah, that holds, like there are some exceptions, for instance, the family domain. The GDPR does not apply when you collect a list of your friends or family or do a birthday party, inviting people. This is not the scope of the GDPR. This is one of the explicit exemptions. But apart from that, it makes no reference to domains, or like with some specific provisions, yes, but in general, it applies to everything. Yeah, the GDPR is actually a very comprehensive instrument, also in terms of its impact. It is often termed or referred to as the Brussels effect, that the EU GDPR has set the industry standard worldwide, and it sparked similar regulations in many other jurisdictions actually. For instance, the CCPA that I was already mentioning, that was effected a little bit later, 2 years later, that took up many of the provisions of the GDPR, making some of them even stronger. But also in many other countries, really around the world, there are similar regulations were adopted. Actually, this is from the perspective of countries in the global south. This is even criticized as a form of colonialism, because it is for like they did not. Some of these countries did not adopt similar regulations because what a good idea, we should do it too. But in order to be able to trade with the EU, because the GDPR sets the standard for you as a country or as a company in another country to enter the European market or to be able to serve as service provider for the European market. And these trade relationships with the EU are very important to many of these countries, especially in the global south, which is why this is actually also an act of imposition to some of these countries and has been criticized as such. Especially if these countries, there are some countries that also go for like a double path, they apply less strict data protection standards to their own citizens and apply GDPR level data protection standards when it gets to trade with the EU. Yes, let's use the rest of this lecture to go through some key principles and rights enshrined in the GDPR. And this is really very important. It is kind of the Einmaleins of the GDPR principles. And I go through it in linear order as it appears in the statute, in the articles of the GDPR. The principle, there's Article 5, that's even titled Principles of the GDPR. The processing of personal data must be lawful, fair, and transparent. Lawful means there must be a legal basis or a legal ground for the processing of personal data. And the list of such is given in Article 6. I will come to that later. Fairness means that data must be handled in ways that people reasonably expect. Yeah, it's unfair if you say I do this, or if you suggest this kind of stuff you offer to me and then you do something completely different with it that I did not expect. And transparency means that controllers and processors must be clear, open, and honest about who they are and how and why they use data subjects' personal data. There is some spicy stuff in this, but I will get back to this when we come to Article 6. Let's first continue in Article 5. Bullet point B is the principle of purpose limitation. This is so important and so central, and I expect all of you to know this, for instance, in the exam. Purpose limitation is this idea that data processing is only allowed when you fix the purpose in advance. Yeah, you must state for what purpose will I process that personal data. It must be stated, it must be legitimate, the purpose, and the data can then only be used for that purpose. It cannot be retroactively used for another purpose. For instance, you collect data for corona contact tracing and then use it in police investigations. This is a breach of data protection purpose limitation principle. No ex post extension of the purpose, no reutilization of the data. And this is the legal text. You can read it in the slides. Another very important principle is data minimization. It's paragraph C, or like bullet point C, and a storage limitation, point E of 5.1. Data minimization means that the data processing is limited to data that are necessary and relevant to the specified purpose. Yeah, it's not like, oh, I collect all the data, maybe more data than I need. No, you cannot. It's unlawful data processing if you collect too much data that you don't really need for the purpose. And the personal data must be kept no longer than needed for the purpose that was specified in advance. That is, when you collect personal data for some purpose and the purpose is fulfilled, then you have to delete it without any further intervention. Like, it's not that the customer has to tell you, please delete it now. No, you have to do it yourself. Yeah, so you have kind of to track your processes, and when the purpose is fulfilled, you have to delete it. And when the data is still there after that, then this is actually a breach of these purpose limitation and storage limitation principle. Point D is accuracy, and the right to accuracy, and connected to this is the right to rectification. That is actually Article 16. I'm combining a little bit here to be quicker in the slides. So Article 5, paragraph 1D is that the processed personal data must be accurate. Yeah, and this is really an obligation on the part of the controller and processor that it must be accurate. Yeah, you cannot just guess it or kind of be sloppy about the quality of the data that you take in. You must do all reasonable measures to ensure that the data is accurate. The personal data is accurate. Data subjects have a right to rectify inaccurate personal data. That can be linked to the right of to get a copy of your data, which we will have on one of the next slides. Yeah, you always have a right of access as a data subject. You can always ask or demand from data processors that they explain to you what kind of data they are processing about you and give you a copy of that data. And then this neatly works together with your right to have your data rectified in case you find errors in that data. And there is also the integrity and confidentiality principle, and that is the data security point that I had on one of the earlier slides in the left yellow box. Yeah, data controllers and processors must ensure to protect personal data against illegitimate access, theft, loss, and destruction or damage. Yeah, this is really, you see how data security is really small also in this regulation. It's only one sub-point of one paragraph of one article. It includes technical and organizational measures. Yeah, that's also a common misunderstanding, that data security is all about computer nerds coding the next level encryption algorithms. But many security measures are actually organizational measures. Yeah, how do you protect access in terms of like that you need many people, for instance, 4I principles, or physical barriers or legal barriers to, for instance, when your company is taken over, acquired by another company, what happens to the data? There can be legal barriers, but maybe you don't do these legal barriers. This is also data security. Data subjects must be informed about breaches. This is actually Article 34, but I put it here because it relates to the integrity and confidentiality principle. Yeah, when your data when you get hacked, you have the obligation to notify your data subjects. It's not that they have to ask about it. Data security, including encryption, protection against theft, hackers, and intruders, is only a small part of data protection. Yeah, there is also an accountability principle, and please remember the concept of accountability from one of the earlier lectures. And I'm directly quoting here paragraph 2, the controller shall be responsible for and be able to demonstrate compliance with paragraph 1. So all the principles that we just mentioned. Yeah, the controller. You see there is a certain, and you remember the accountability lecture, that it's always like relationships of delegation. And it's really the responsibility of the controller to be able to demonstrate that they comply with all these principles, the data processing. Yeah, maybe one of the most important points is Article 6. As we had in the first slide, data processing must be lawful, fair, and transparent. So what does lawful mean? And this is also one thing that I want you to remember, potentially for the exam and for your life. The architecture of the GDPR is like this. Data processing is generally prohibited. Dot. Next sentence. Unless there is a legal basis. Yeah, so there is a prohibition by default, and only if a positive list of criteria is met, only then is it allowed. This is a very stark approach, if you notice, yeah, prohibiting something generally and then listing the circumstances when it is allowed. And one of the ingredients, one of the conditions, it's not a sufficient but a necessary condition for it to be allowed, is that it matches one of 6 available legal bases which are listed in Article 6. And these legal bases are, for instance, that you obtained consent, yeah, that the subjects gave their consent to the processing of this data. This is a huge exception, which is actually a very bad thing, because it's so easy to get consent, and then all the not all the prohibitions, but then you immediately enter the threshold that it is allowed to process the data. Maybe it's required by your contract. Yeah, if you offer somebody a contract to do this and that, and you really need the data for that, then you automatically have the allowance, and you don't need an extra consent. You might be legally obliged to process certain data, which applies, for instance, in the healthcare system, finance system, police, but the police has different statutes anyway. There might be vital interests, for instance, if it is necessary. When you have an emergency, a medical emergency, then for instance, the emergency system can immediately process your data without asking for your consent or another legal basis, because it's vital to your survival. If you fulfill a public task, whatever that is, and maybe most interestingly, there is also this provision or this legal basis of legitimate interest. This is the most flexible and at the same time most opaque basis. It includes commercial interests. In general, the condition of legitimate interest applies when the data subject should reasonably expect that their data is used in that way. If the processing isn't required by the law, but there is a clear benefit from it, and if there is little risk of the processing to infringe on data subjects' privacy. Yeah, it's, for instance, it has been a huge debate. For instance, is a targeted advertisement or cookie banner tracking, website tracking, is that covered by legitimate interest or not? I think there has been a ruling a couple of years ago, that it isn't. But this is definitely one of the categories that is being tried to use for, or to extend for certain purposes that are politically hot. Article 9. It's important to know that the GDPR makes a distinction not only between personal data and anonymous data, but also between personal data and sensitive data. This is the so-called special categories of data in Article 9. And that is personal data revealing racial or ethnic origin, political opinions, or religious or philosophical beliefs, genetic data, biometric data if used for identification purposes, data concerning your health, so medical data of all kinds, data concerning a person's sex life or sexual orientation. And this is also these special category data are usually referred to as sensitive personal data. Yeah, this is a subgroup of personal data for which there are extra prohibitions. And this is then in paragraph 2 of Article 9, where you find that processing of sensitive personal data is kind of always prohibited except for these circumstances. And this is a stricter regulation compared to the general processing of personal data. I will not read through this because we have to save the time. Article 15 enshrines a right of access. I already told you, the data processors must provide information on the collected personal data about a data subject. It must provide a copy to you. This is actually not only an invention by the GDPR, but it's also in the EU Charter of Fundamental Rights. So this is really a thing, and in the US, they also have it in many domain-specific legislations. So it's very important to be able to fight illegitimate or inaccurate data processing. It's really a fundamental building block of enabling data subjects to do anything legally. Otherwise, you can never sue a data processor. And there are also online generators for right of access requests. If you want to annoy some of your favorite data processors or big data companies, you should make a huge party where you invite 200 people and all of them file an information request that could be auto-generated by such a thing. You also have a right to erasure, especially when you withdraw your consent. I don't want to go through it. If you, for instance, if your personal data is being processed based on your consent, that was the first legal basis, you always have the right to withdraw your consent. And that has the effect that the processor must immediately erase the data that was being processed based on your consent. And the thing is, there's a caveat to which I would like to point you, because I will come back to that in the next lecture when it comes to limitations in the face of AI. The right to erasure can also be satisfied by anonymization instead of deleting of the personal data. So if you, for instance, agree to some tracking data being collected, or your telephone company using data for statistical analytics, which means machine learning, and later withdraw your consent, they will not have to undo, for instance, the training of machine learning models if they did it in an anonymizing fashion after you withdraw your consent. So after anonymization, personal data can still be used for data analytics and as AI training data, for instance, in recommender systems, scoring systems, behavioral profiling, and so on, as long as it can be done with the anonymized version of your data. And there is also this notorious Article 22 on automated individual decision-making, including profiling. This is actually one of the examples, and please allow me for these 3 extra minutes, then I'm done. This is one of the notorious examples of the lobby work that has been done on the GDPR, because before the lobbying intervention by big data industry, that was a stricter prohibition, and now it is actually only a toothless tiger. But let's first ask, what is the definition of profiling according to the GDPR? That is, profiling means any form of automated processing of personal data to evaluate certain personal aspects relating to a natural person, in particular to analyze or predict aspects concerning the natural person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. That's a very rich definition of profiling, isn't it? There are all the hotspot, politically problematic profiling things that you might want to do in there. And then here comes Article 22. The data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her. You see the term fully automatic? This was, the 2 words were lobbied into the prohibition. It only applies when the processing is the automated decision making is fully automated, but not semi-automated, for instance. And then comes in paragraph 2, there are the exceptions. Paragraph 1 shall not apply if the decision is necessary for entering into or performance of a contract. When you apply for a bank account or a credit, arguably it is necessary, so this is already a huge exemption. And then point C is based on explicit consent. When you sign up for a bank account or a credit, you will give your consent to some Schufa magic. You will not even be eligible to apply without it. So I stopped reading this out now because I made the point already clear. There is another caveat. The provisions on profiling and automated decision making in Article 22 they are limited to fully automated processing, and this is actually the main limitation why this is largely ineffective and has been widely debated as such. In practice, putting a human in the loop that just clicks OK, the assessment is done automatically, but there is somebody in a sweatshop that always clicks OK, or that broadly reviews the decision and then clicks OK. This is then a semi-automated system, and then it is exempted from this whole paragraph. In most delicate cases, consent will be obtained from the user anyway. For instance, when it's about real-time credit scoring, automated employment decisions. Yeah, when you are scored in a job interview, you will have to consent to it. And then again, Article 22 will not save you from being subject to automated decisions.
Okay, and today I would like to transition to the more recent, so even more recent than the GDPR, EU Digital Acts, and give you some overview of the AI Act. And the thing is, talking about EU digital legislation, especially from a point of view of philosophy, is very hard. And I was really wondering how to bring that to you. Because the thing is, there are more than 70 already applicable, or roughly 70 already applicable, and roughly 30 coming EU digital legislation acts. Yeah, there are many different acts, so pieces of legislation that are relevant for the digital market or the digital sector, and it's very difficult to even tell them apart or get an overview. So what is the difference between the Data Act and the Data Governance Act? And what is the difference between the Digital Services Act and the Digital Market Act, and so on. I highlighted some of the acts that I will be talking about here today. You cannot even read it, right? Probably not. Okay, I see. The thing is, I can even also not read it here on my screen, which makes it very difficult. Here is the general. I will need to put the cursor here. Here is the General Data Protection Regulation. You know that already. Here is the Data Governance Act. Here is the Data Act, and here is the European Health Data Space Regulation. So these are all data-related stuffs: GDPR, Data Governance Act, Data Act, and Health Data Space. And here is the AI Act, the famous one, yeah. And here is the DSA, Digital Services Act, and here is the Digital Market Act. I will pick out these 7 today, or in the next maybe 10 minutes to briefly sketch them, because I think these are the 7 most important for you to at least have heard the term before. And then I will talk in more detail about the AI Act only. But only that you see that this is really a huge ecosystem of legislation that's being implemented. The deep blue pieces are already effective, while the lighter blue ones are here proposed. So they are in the parliamentary process, for instance, or in the legislative process, but not effective yet. And the very light blue ones are proposed or envisioned only. So let's start with the 4 here on the left column, the 4 more data-related acts. These here. The GDPR you know already, because we had the full lecture about it. It was adopted, so that is the final decision in 2016 and took effect in 2018. There is also the Data Governance Act, and that was adopted and enforced in 2022. And the Data Governance Act is a regulation that specifically focuses the sharing of sensitive data or personal data held by public bodies and regulate data sharing in the private sector. So it's about, in a way, it is a big data related regulation that that they wanted to establish standards and legal requirements for the use of aggregate data sets that contain sensitive data about individuals. For instance, the data of public bodies, of private companies and citizens. So the idea is that that one should enable the benefits that you can harvest from big data and analytics and so on. There's also the Data Act. It will be enforced only, I think, in the course of this year, but I couldn't find the exact date. Maybe it's not yet clear. But it was adopted in 2020, like in December 23. And that is a specific regulation aiming IoT devices. So there is now an increasing amount of data originating from Internet of Things devices of all kinds, from the smartwatch to the fridge or to all these sensors and smart home applications and so on. And the EU put up a regulation that enables and regulates the exchange of IoT data and that has in mind an equitable distribution of value created from it. That means something like they were kind of requiring standards of, for instance, including portability, so that IoT devices need to be able to connect to other devices from other companies or from other platforms, or need to have interfaces that so that you can obtain the data. So that you get not locked in the ecosystem of only one company or of only one manufacturer. That I think is part of this regulation. It will be enforced at some point later this year. And then there is, and this is also a very interesting example also for my research, there's the European Health Data Space, EHDS. It is also a domain-specific legislation that targets data sharing in the health sector. So it's about all health data, from patient data to what data hospitals generate, or data that are generated in medical research and so on. And also here it is about, and this is really important to take away, these legislations, the same, that's not only in the EU but also in the US. These kinds of legislations always have two sides of the coin. The one is enabling and harmonizing standards, so enabling data sharing and data processing under certain terms, and on the other hand it's regulating it in the sense of restricting it. But I mean, the political process is always that there are at least two different political camps that have some interests in these regulations. And it's not only about repressing or restricting it. The GDPR is also a regulation that first and foremost also enables data processing, provides legal bases and provides legal certainty that you can do it. And the same goes here in the EHDS. Whose purpose is to provide kind of more clarity on what you can do with health data and what you can't do. The EHDS is an interesting example for my research, because in the EHDS is, to my knowledge, the first legislation that comes with provisions on the risk of secondary use of anonymized data. I will talk about that next week in more detail, but to pitch it to you very quickly, when you anonymize data, or if you train from data, for instance, a machine learning model, in a way that the resulting model data is anonymous data, which you can do if you take care, then you are not in the scope of the GDPR anymore, right? And because it's anonymous data, and so you can reuse these models potentially for other purposes. And the EHDS comes up with a positive and negative list of allowed purposes and forbidden purposes. And this is very relevant, and in my research I'm calling for this to happen in much more domains, in many more domains, but I will explain to you better next week. But just that you keep in mind that the EHDS is in a way a very progressive example. Let's get to the second column, like to the right column, or the right cluster of red boxes I had on this overview, which is the DMA DSA AI Act, these three. And maybe that's even more, I don't know, I think you heard about this more in the news than about the Data Act or Data Governance Act. But so this is really maybe one of the hard piece of the EU, of the most recent EU digital legislation. The DMA, the Digital Market Act, is about balancing market power. Yeah, it's about these gatekeepers. So platforms as gatekeepers, platforms that keep other manufacturers outside of themselves, like Apple, shielding its whole ecosystem off against other manufacturers, and certain internet platforms trying to be gated communities. And so it defines this term gatekeeper, which is interesting that a legislation does define such a kind of power strategy as a defining criteria for a certain type of company. And the DMA specifically targets these power, the resulting power for very large online platforms, with the aim of ensuring competition. This is also how you can sell it to the more pro-business and more conservative political camps, that this is about ensuring competition, for instance, of European companies against major platform companies. The DSA, the Digital Services Act, it took effect only recently in February. There were even like events because that was long waited and long celebrated that we have this DSA, because it is the European Union's attempt to attack or tackle the risk of misinformation, for instance, or fake news or illegal content and abusive content in social media or in online platforms. Also including search engines and so on. So they have this category of, like, they stagger, I think, the treatment by the size of the platform, which is also something that's being criticized. Yeah, why would revenge porn on a platform that has only 10 million users not be an equal problem compared to the same piece of content on a large social network that has billions of users? You can still dox the persons, you can still trigger consequences for the victims and so on. So that has also been criticized, that they go by size of the platform, but they have this category of systemic risk, which is also, I would say, a progressive innovation, that a legislation acknowledges that there is systemic risk resulting from online platforms, and they try to implement legislation that, for instance, prescribes how content moderation has, or the requirements for content moderation. And here, for instance, they went for this flagging model, yeah, that you have to provide a flagging infrastructure. So users who flag illegal contents are the first in the pipe. So you make, in a way, use of these of the labor, the free labor of the users. You have to provide this flagging infrastructure, and you do not, for instance, have to provide that, like, a structure that checks the content before it goes live. Yeah, that was also a debated decision, like or they, let alone a public body that makes these decisions. So politically, there were many options that you could, or theoretically, there were many options how you could, for instance, improve content moderation, but they went for the, I would say, rather minimal requirements that boil down to a flagging infrastructure. Yeah, and then there is the AI Act, which is also a stunning piece of legislation. It was adopted this year, and I'm not sure when it will be effective. I think there is not yet a date out there, but it will be in the next months. It is stunning because it's the world's first comprehensive AI legislation or regulation. Like, it's really the attempt to provide a unified legal framework for all kinds of AI, whatever that is, future and present and future. So that was maybe one of the largest challenges in the AI Act, that what is AI? The AI Act doesn't really define it, or for good reasons, because maybe in 2 years AI is something different than it is today. So how you should not be too narrow in the definition if you want to come up with a universal regulation for AI. And of course, then people were coming and saying, yeah, look, but if you don't know what AI is in a couple of years, how can you regulate it in such a way that it will not hinder innovation or the free unfolding of science and industrial research and so on? And then there came ChatGPT. That was also something that I would say delayed the AI Act for maybe a year. That at some point ChatGPT came, and then the whole thing was debated again, because apparently the AI Act before ChatGPT did not have a take on general purpose AI and generative AI, and now it is a specific category in the AI Act. So that was last minute altered by the new situation due to ChatGPT. Yeah, let's talk about this in a little bit more detail. What is the objective and approach of the AI Act? As I told you, to be general, and it is very remarkable, and that's why I put it as the next point. And although they want to be general and cover all kinds of AI systems, they made a huge exceptions for what is often called open source models. If they are open source models, but I really don't like the term, and I will always put them in quotes, because to me open source, I mean, here what they mean, or what is meant when people talk about open source AI, is when you publish the weights, the internal parameters of the trained models on a free license. But like open source in software means not publishing the compiled executable that you compile from some source code, publish it freely, but it's publishing the source code, right? And publishing, and going by that analogy, publishing the source code would mean publishing the training data, and this is not what they imply, which I find actually very risky for reasons that I will explain to you next week. So this is why I think this is a huge scam in a way. They are using the positive image or the positive connotation of the term open source to legitimize something that I find highly problematic, as I will explain to you next week. So I outed myself up front now as a huge critique of open source AI. They also accept AI systems built solely for the purpose of police or national security or military, which are arguably very, very heavy AI application domains with huge impacts, and they are completely exempted from the scope of the AI Act, which is for some a huge scandal. For instance, think about biometrics or facial recognition in police work and so on. There are provisions of facial recognition, I will tell you. The second remarkable point that you should keep in mind, although I think it's maybe not easy to understand what is the full meaning of this, and I try my best to explain it to you today, but I hope I succeed. The AI Act is a product liability scheme, a product liability regime, ein Produkthaftungsansatz. That means the idea, like, it is not so what does it compare to? it is not an approach, for instance, that protects fundamental rights. It's not like data protection, which is, it's all built from the idea of we need to protect violations of fundamental rights. No, here the idea is we need to regulate the industry to make AI systems safe or risk-free, or to manage and control the risk that comes with AI systems. And as one of the first consequences, the AI Act does not confer any rights to on individuals, like defense rights, for instance. It puts out, or it sets out certain requirements and obligations to the providers and the manufacturers of AI systems, but it does not give you certain rights to sue or to defend yourself against impact by AI systems. I think it is not false to compare it to how, for instance, product safety. When I hear product safety, I think of these regulations that say, for instance, power points in the wall, like power sockets. They need to adhere to certain standards, like ISO irgendwas standards, so that it is in a way guaranteed that I will not get an electric shock when I touch them, or that they don't break apart, and so on. And this is, it's also the legislation, the EU product safety legislations for power sockets does not confer any additional rights on me. Yeah, it's not. I don't have a specific right not to suffer from an electric shock by a power socket. That would be in a way ridiculous. It's only that you cannot sell power sockets in the EU that do not adhere to certain industry standards or norms. And the same idea is now transferred to AI. Yeah, you cannot sell or provide AI systems in the EU that do not adhere to specific industry standards that need to be worked out by European standardization organizations. And the AI Act is largely a procedural regime. Yeah, it says that AI systems need to adhere to certain industry standards, but it does not say the content of these industry standards. And for instance, working out or deciding on these internet standards is delegated to standardization organizations, and with this many of the interesting ethical questions are actually delegated to standardization organizations, and in a way kind of exempted or left out from the democratic or legislation process. Yeah, it's also that the parliament did not decide on how power sockets need to look like so that they are safe. That was kind of left, as the parliament only decides you cannot sell a power socket that is not safe, that doesn't adhere to certain standards, and then what do we need? What requirements do we need to impose on power sockets? That should be left to engineers to decide, because they can kind of figure it out. And the same, very schematically, is now done with AI systems. Yeah, and as such a product liability or product safety regime, the AI Act comes with a risk-based approach or risk-based stratification. It classifies AI systems by their risk of causing harm, and I will go into these risk categories in a second. So unlike the situation with power sockets, where I think there are no different risk class, but I don't really know. In AI, they kind of make a stratified approach, so it's all much more complex than regulating power sockets. And as I said, it's a procedural regime. It delegates many value questions to standardization and only prescribes the procedure. Let's look at the risk categories, because that is maybe the one of the things you should remember about the AI Act. It comes with 5 different risk categories. The risk category number 1 is unacceptable risks. That is AI systems that manipulate human behavior, that use real-time remote biometric identification, for instance facial recognition, but also other biometrics, for instance by voice or emotion analysis, no, it needs to be identifying. So identifying you from your voice in public spaces, that provides social scoring, for instance. Yeah, that is the idea of ranking individuals based on their personal characteristics, socioeconomic status or behavior. So that is kind of the impact of the Chinese social sorting, social scoring systems on the EU legislation. And if these conditions are fulfilled for a certain AI system, like AI systems that meet these conditions, what will be done with them? They are banned. That is the idea. That's why the risk is unacceptable. So the EU says, okay, this is ruled out. You cannot build or deploy these AI systems in the EU. It's interesting because there is real-time remote biometric identification, for instance, facial recognition in public spaces. There are two, and this is actually one of the things that has been heavily criticized, how the ruling out of facial recognition has in the end been boiled down to, or there are many exceptions. Yeah, it's only for public space. So if you in your company, for instance, want to install automatic doors that open by facial recognition, that is not banned. I don't know. What about the shopping mall? Because these are also private spaces. That is interesting. So if you want to follow around your customers by facial recognition, for instance, for targeted advertising purposes and so on, I'm interested how this would be decided based on the AI Act, if that's possible or not. And also, and most importantly, there is this exception that the ban goes only for real time. And so if the police, and when does actually real time stop? Yeah, if the police records a demo or protests outside with the camera, they cannot use real time facial recognition to see who is in the crowd. But like how long has the delay? How long of a delay do we need to kind of put between the recording and the analysis? Is 10 seconds enough? Is it a minute? Is it half an hour? For sure, the police can use the recording of the demonstration and one day later use facial recognition to see who was on that demo. But that has been heavily criticized. Because it's actually a very weak restriction. For me, it reminds me of Article 22 in the GDPR, where the banning of automated decision systems was kind of boiled down to fully automated decision systems. Category 2 is high risk. It applies to AI systems that are expected to pose significant threats to health, safety, or the fundamental rights of persons. Yeah, that are the vague criteria, and for instance, it applies to all systems that are then used in the health sector, in the education sector, in recruitment. That's very desirable, actually. In critical infrastructure management, law enforcement, justice system. Yeah, all these examples that we had, for instance, the Compass scoring system that scores criminal recidivism, or when you use AI in job applications or in human resource management and so on, that is classified as high risk. Because it can easily threaten the fundamental rights of people. Yeah, for instance, in human resource management, it could be the risk that you are discriminated and so on. And importantly also, the list of criteria that make for a high-risk system can be expanded over time without modifying the AI Act itself. So it is also a kind of the AI Act only refers to another place where these things are listed, and that other place can easily be amended. Now, what are the consequences for these systems? So if your system is classified as high risk in the EU, what does it mean? It doesn't mean that this is banned, but it means that you have to adhere to the strictest set of requirements and obligations under the AI Act, and that is quality obligations, transparency, human oversight and safety requirements. Of course, these requirements are listed in more detail in the AI Act, and I will not cover this in full detail here. But the thing is that in the end, this always boils down to standardization, to the work of standardization organizations. So what transparency for a automated job applicant screening system means is not written down in the AI Act. Yeah, that there will need to be an industry standard emerging in over the next time that sets the industry standard for transparency in HR AI systems, for instance. And under some certain circumstances, these companies need to do a fundamental rights impact assessment. Yeah, this is always an instrument. You know, this is also in the GDPR, but I didn't tell you last time. It is a measure where the entity, the company, is forced to kind of do by a certain methodology an impact assessment. So assessing what could be potential impacts of my system on the fundamental rights. And that impact assessment, I think, doesn't need to be published, but needs to be there when the oversight body comes and wants to see it. I would say it's a rather weak instrument. And this is even most important, and also something that you should keep in mind. All these requirements are self-assessment requirements. So it's not that there is an oversight body that comes to your company before you launch your AI product and says, we have to investigate everything and then we give you the go. But it is more that if you want to launch a high-risk AI system, you need to do all these assessments and all the compliance work yourself, and then you launch the product. And if there is a complaint or any suspicion, then an oversight body might come and see whether you comply or not, or whether you did the assessments. So this is really the approach. I mean, it also has benefits because it means that the time to market, I mean, if you would, before you can go to the market with your product, if you need to wait for a public body to review your case, that is again this kind of bureaucracy that takes ages and that slows down innovation or the economic timeline, because it adds bureaucracy to the pipe, and there is already so much bureaucracy in the pipe. This is why I think they kind of delegated, or this framework here delegates the compliance work to economic actors. Yeah, companies would either do it themselves if they are huge companies that can hire the lawyers and what it needs to do all the compliance work, or there will be service providers, like private service providers, which means law companies that provide auditing services to companies, and then you will have to pay them to get your auditing, your compliance, and then you have it, and then you go live, and if the EU oversight body has any questions, they will come and review your self-assessments. Risk category 3 is general purpose AI, and this is what I mentioned earlier, that has been only added in the last months. So they really, it's very interesting that they add general purpose AI as a risk category, or not, to put it differently, to describe a risk category by general purpose AI. And this risk category of general purpose AI covers foundational models such as GPT 3 or 4, like that. That's what's behind ChatGPT. And there is a subcategory of high impact general purpose AI, which are models trained with more than 10 to the 25 flops. So that is a certain compute threshold. Yeah, the computing power threshold. If you that are supposed to be very mighty models. It has been hugely criticized that this is actually a viable threshold that really reliably corresponds with a risk level, but That's what has been decided. So GPT-4 would just fall within that threshold. It's a very high threshold. Yeah, if you have such a system, then you again have a certain list of obligations, and that is again transparency and copyright obligations. Yeah, you have to make transparent, for instance, how your model was trained, and how you did test your model that it complies with other legal standards such as copyright, or that it does not produce false information or manipulative information. And you also have the requirement that you need to disclose to the users that this is an AI generated content. I'm very curious to see how this plays out, for instance, when news articles, for instance, are then written with AI, whether we will see a little flag or a little tag next to the news article, like this was generated using AI, or with certain images. Like now we see on social media, when there is an ad, then there's usually because that is the result of the DSA, right? Yeah, Digital Services Act asks the providers to really mark ads as ads, and also if it's a targeted ad, you need to have a button that explains to you why you see this ad. We see this, yeah, and I'm curious to see how this will materialize, whether we will see more of these flags next to articles and so on. Yeah, and people, like companies are required, whatever that means, and it's so unclear and vague, to design the models to prevent it from generating illegal content. I think that's what you already see in ChatGPT, that the model does certain things, and then there is a layer behind the output of the model that filters out certain stuff. Yeah, if you engage with ChatGPT in a pornographic story, for instance, then very early you could see like this conversation was interrupted by a certain human oversight. Yeah, you could see that they used filters, and then your conversation went to some click workers that made the decision, this goes in a bad direction, so we cut the conversation, and you would only see a notification that this conversation was being ended. And now the ChatGPT would, I think, just answer that it is not supposed to. I don't know. But always there seems to be some kind of a layer that is appended to the actual model. Yeah, and they also have certain transparency obligations with respect to what they put in the training data, although nobody knows how this will in the end look like. And importantly, generative AI, including stuff like ChatGPT or Midjourney and so on, are not classified as high risk. Although many people say that the risks of these systems are higher than of most systems that we knew before, but these have not been classified as high risk. There was the proposal, and that was heavily debated last autumn. And I think in the end the industry prevailed in boiling down the risk or playing down the risks and not classifying it generally as high risk. There's also the limited risk category. Sorry, it gets boring, I know that, but the thing is, it is, I would say, politically spicy, because in the limited risk category there are things like, first, all systems that have not yet been covered in the list, yeah, so all the remaining systems, if they interact with humans, detect emotions, categorize people, generate or manipulate content. So if you have an AI system that is not a general purpose AI system, such as a large language model, but a more simple AI system, for instance, a deepfake system, like a system that can replace your head by the head of Angela Merkel in an image, or that can produce Obama giving a speech that he never gave, or that can produce revenge porn. These kinds of systems have been classified as limited risk systems in the AI Act. Also a thing that has been heavily criticized, especially with respect to political disinformation, yeah, when you deepfake certain images or videos, or with respect to the risk of revenge porn, the consequences, if your system is classified like that, they are really ridiculously simple, the consequences. The one thing is that you have transparency obligations, and that means that you have to inform the users that they are interacting with an AI system. So if you put a chatbot, a customer support chatbot on your web page of your online store, it has been to be visible that this is an AI system. Okay, we can do that. If you get an AI generated customer support answer, like if you write to customer support of I don't know, YouTube, and then AI sends you back the answer, then I think they have to state that this was generated by AI. But how does that work in the case of deepfake? What's the idea here? Because obviously the systems are being abused anyway, so deploying the systems should be regulated, and not that you have to mark the outcome as this was generated by AI, because that can easily be left out, and then the harm is done by circulating these videos, for instance. Yeah, and then all the still remaining systems, that do not fall in this category are in the minimal risk category, and the minimal risk category has no obligations or nearly no obligations. All other AI systems, for instance, systems used for video games or spam filters, and they only have the one requirement that, or the AI Act makes the one provision that these systems are not regulated, and that member states cannot impose stricter regulations on these systems. So this is a guarantee to the industry that for harmonized rules. Yeah, this is always this EU harmonization idea. Okay, now that we went through the risk categories, let's kind of really try to write down some of the key limitations and exemptions. The one hot topic is biometrics and facial recognition. I told you already a little bit. Algorithmic video surveillance is banned only if conducted in real time, but not banned for policing aims in the context of a real and present or foreseeable threat of terrorist attack. Yeah, this is the second exemption that I did not mention before. So the police cannot use it in real time, but this ban does not apply if the police says there is a real and present or foreseeable threat of terrorist attack. And this is a hugely vague provision, and we will be curious to see what will be the occasions for the security apparatus to make use of these exceptions, and against which groups of people, against which protests and so on that might be used. Biometric identification systems generally are categorized as high risk. Yeah, for instance, you unlock your smartphone screen, or when you when a company wants to use this as access barriers to their premises and so on. And when state actors use these identification systems, for instance law enforcement, then it is unacceptable risk. That's good to know and important. I mean, I think they had the problem that classifying facial recognition generally as unacceptable would immediately put an end to all these smartphone unlocking features and so on. I'm not sure I think there was too much reality was kind of against this idea because so many people use it. The other big or the other very contested bundle of exemptions in the AI Act refers to social scoring. This is also, I think, something that I want to cover here briefly in one slide. The AI Act prohibits AI systems provided for that provide social scoring of natural persons by public or private actors. Yeah, that's the unacceptable risk category. I refer to the Chinese and so on social scoring system. But, and this is, I would say, delicate, it allows for lawful evaluation practices of natural persons that are carried out for a specific purpose in accordance with union and national law. That's weird, and commentators have been pointing out that behind this is something like a sector-specific social scoring, like that. This is that a sector-specific social scoring is enabled. For instance, in France or in the Netherlands, there are AI systems that predict the risk of abuse of child benefits or welfare benefits, or many, I think, tax offices or tax bodies would like to employ AI to detect who might be suspected of tax abuse or tax crimes. So apparently there is a mechanism that enables scoring, like suspicion scores, or like scoring people by suspicion or by a risk of criminal activity in specific domains that have to do with the abuse of, for instance, benefits or tax avoidance and so on. Or no, tax avoidance certainly not, because that's what the rich people do. Another set of exceptions is open source models. Models whose weights are freely published and generally exempt from the AI Act. And did we all follow the news in December when this was one of the last minute negotiation points, on the last final meetups before the AI Act was then agreed between in the trilogue process. And didn't we all see in the news how Mistral was published? Like in the next day, the company announced that Mistral was then made open source so that they could avoid the AI Act obligations, because this was a powerful model, and so they tried to avoid it by making the model open source, open weight. Yeah, and the only exception to that is that if the company monetizes the model as a high risk system by their creator. But I think that the business strategy for Mistral was not to monetize it as a high risk, as something that would be classified high risk, but only as something that would be classified a general purpose risk and but not high risk. Yeah, and so that I think is a route that was heavily the result of heavy pressure by the German and French industry to provide for these exceptions. And only transparency obligations for general purpose AI models are lifted. The transparency obligations for general purpose AI models are lifted if the model is published free and open source. Yeah, that is, I would say it's a potentially heavy mistake. But I will argue that case next week. Institutional governance. Yeah, how does what mechanism does the AI Act foresee to enforce itself, or to kind of implement a governance structure that makes sure that all this is being enforced? The AI Act mandates to establish an AI office, an EU AI office that will be attached to the EEC, to the European Commission. I think that is the central oversight body of the whole AI Act consequences. Like, they will not individually oversight each single company, but it's more that they oversee the whole enforcement infrastructure of the AI Act. Then there will be a European AI board, where each member state sends one representative, and that board will kind of have an advisory role and assist the Commission and member states to facilitate the consistent and effective application of the AI Act. Then there will be an advisory forum that is established to advise also the EC and the AI office. And in the AI advisory forum, the idea is to gather stakeholders. Yeah, so the AI board consists of the member states, the AI forum consists of stakeholders, and however they will be selected, I don't know for sure, but they are supposed to include industry, startups, small and medium-sized enterprises, civil society, and academia, ensuring that a broad spectrum of opinions is represented during the implementation and application process. So this is, I think, the point where, for instance, also representatives of marginalized groups and other interest groups can enter in through the civil society ticket. And then there will be a scientific panel, that's a scientific advisory board composed of independent experts appointed by the European Commission that will also advise the AI office. So there is, to me, that sounds like a lot of non-committal and rather vague advisory infrastructure at work, and all the rest remains with the AI office. And I think it will be also a highly political thing how this will be, who will be appointed in this AI office, and how political, or how will they do this work with what political ambitions and implications. And now, I told you already, but to be a little bit more specific on that point, the AI Act delegates the concrete requirements and obligations to standardization processes. And only to show you what that means, there are so many points. And I put I used this research paper here, I linked it down there, and copied this table from there. They list already these 10 things or 10 topics that will be in need of standardization. For instance, what does it mean to be what does transparency mean, and how does information of the users, that this is has been generated by AI, for instance, or that they're interacting with an AI system, or that their data is being used to train AI, and so on. How does that need to look like? What does it mean what does human oversight mean? What requirements do we want to impose on human oversight, and so on. So you see that all the details, and there is potentially a lot of room for to make a difference, or for ethical considerations in how you rule this, or how you will create this in detail. And that is left to the standardization processes, which are not parliamentary processes, but processes by standardization organizations such as DIN or ISO and other European standardization bodies. Criticism, to summarize some of the critique that was already mentioned. There's a huge trust in self-assessment. Companies do the assessments themselves. Also, by the way, the main point of self-assessment already starts in classifying your system. Is which risk level is your system? It's not that the AI office tells you, but it's that you need to assess that yourself. And there will, of course, be a lot of, of course, on the one hand, you will have to make sure that you are not underestimating the risk of your system, because I think the consequences that you might be sanctioned and so on if you classified the risk wrongly. But at the same time, I think there will be a lot playing with it, or kind of downplaying certain corner case applications that might be high risk, so that you can deliver it as a general purpose AI system, or as a low risk system, and so on. And this is then not something that is done by independent experts or by delegates of stakeholders, but by the companies themselves, potentially in collaboration with auditing providers, so commercial legal companies that provide auditing services. The standardization processes will. It's unclear to me, and not only to me, how democratic that is. There are frameworks in the EU how standardization processes have to work, so it's not completely a black box, but the question still is how much democracy on very central value questions or central ethical questions will be in there. The exceptions of biometrics and facial recognition, of military and police use, the loopholes for domain-specific social scoring, I mentioned them, the open source exemptions, and that stuff like deepfakes, which are such a huge instrument in disinformation and personal defamation of people, should be classified as high risks. That's what many people call for.
Okay, I hope it worked for you listening to these 3 parts where I reused the recordings from the last year. We are now finished with the lecture, but I would like to remind you once again to please participate in the official course evaluation for this course. Please use this QR code or type the URL below. It takes you 5 minutes. It's a great help to us to get your feedback. Yeah, and see you next time in the lecture hall to continue with the last session. Next week, I will give an outlook on more cutting edge topics in AI regulation and data protection. I will actually talk about my own research in these fields and give you some kind of overview of what we are doing in our group in terms of AI regulation problems and proposals. See you next week.